here. Welcome Judge Barber on that end. Thank you. And everybody who's over there. First of all, I'd like to shout out and thank you to all the techno people who are helping us both on that end and this end. We are also video conferencing in some other folks. Last time we tried that, that didn't work out so great for some of those people. So if you're listening to this right now via video conference, please shoot me an email and let me know how the experience was, because we've made some improvements. This presentation will also be available on the Ninth Judicial website under my name. If you've got friends who want to go watch it, they can contact me later and get the all-important CLE number. I'm going to give that to you now. I'm going to try to remember to do it again at the end. Email me if you don't get it right or I say it wrong. I'm going to be sneaking out on this end by 1-1 because I've got a hearing in Osceola to get to. So if all of a sudden, Judge Barber, you don't see me here, that's where I've been. All right, the number is 160-6017N as in Nancy. 160-6107N as in Nancy. So we're here today to talk.
Wait a minute.
Did I? 160-6017N. And that's why you don't want to have your math cases in front of me. All right, so we're here today to talk about one of my favorite topics, attorney's fees. And in keeping with Judge Barber and I's good cop, bad cop routine down in Osceola County, I will be talking about bad actors and 75-105, and then she's going to talk to you about the very important 6116 fees, which are your more traditional need, ability to pay. And I want you to pay super close attention to what she has to tell you, because we have both been experiencing lately some problems in lawyers bringing to us what they need to prove that reasonableness of fees, and having what we feel like is a record that will withstand appeal. So please pay extra close attention when Judge Barber talks to you. So let's talk about 57-105 for a minute. And let me just say at the jump that this is controversial. There are a lot of people in this room, in this building, that wear black dresses to work that are going to disagree with what I'm about to say. I like 57-105, and I think it's underutilized, although it should not be abused. In my feeling, now being on the bench, and this is my feeling as a practitioner too, there are very few ways that we can deter litigants from filing baloney. Very few ways. Fees as a sanction is just about the only tool a judge has to keep folks from doing that. So I personally believe in it. I believed in it as a lawyer. I believe in it as a judge. So here are the rules. Number one, you need to evaluate the situation where you want to use it very carefully. All right, we're not Miami. Trust me, you don't want to practice in Miami. I'm not trying to make us Miami. Evaluate it very carefully. Keep in mind that 57-105 applies not just to the pleading as a whole, but to individual parts of a pleading. And I'm going to use as my example for today petitions for modification, because that just happens to be the area that I feel is the most utterly abused. If you get a petition for modification, you know, my kid's 16 now and this is what he wants, you know, or whatever. And the shorter they are, usually the worse they are. And you feel that you have a 57-105 claim, then this is how you go about doing it. But again, back to my first point, it doesn't just have to be the pleading as a whole. It can be some individual part of a pleading. And it doesn't have to be an original petition or a petition for modification. It can be an answer. It can be a request for discovery. I mean, it really does apply to anything that is an assertion of law or fact that is not well-based. Doesn't have to be frivolous anymore, just well-based. If it's not based in the law and the fact, it can be any portion of therein be subject to 57-105. But here's what you've got to do to make this stick. And by stick, I mean once you follow these directions accordingly, and you've got the right kind of case or the right kind of claim, and you prevail, these attorney's fees are shall. You are guaranteed to get attorney's fees under 57-105 if you prevail and you follow the directions. And the directions are, you have to do a safety harbor notice. You have to send a notice to the other party You do not file it. No, 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 no. It can look like a pleading. That's usually how mine looked. It looks like a pleading. You send it to the other side. You say, notice of intent to seek fees under 57-105. And then you go and you have put this in your pleading, and it's baloney. I always preferred, and I think it's safer if you go the extra step and say, it's not well-founded under the law because of this statute, in this case, and this case. It's not well-founded in the facts because you do or should know that that's not true, and that's not true, and that's not true. And then you send it to the other side. And they now have 20 days to fix things. They can dismiss the pleading, they can seek to file an amended. If you haven't filed an answer, they can go ahead and file an amended. They get a chance to fix things. My suggestion to you is that when you get one of those notices, you don't ball it up and go, ha, sour grapes. You take a pretty good look at it. I take a pretty good look at it. I take an objective look at it. We all, and by we I mean litigants, lawyers for litigants, and I wasn't there very long ago, we drink the Kool-Aid. I get it. You come in and you really, really, really do believe your client's position, and when they say to you, Dad was arrested 3 weeks ago for aggravated assault on a baby, you have no reason not to believe that, and and you put that in your pleading and you sign it and they swear to it, and you think everything's good. When you get the 57-105 that says, yeah, actually, that's not what happened. He was the victim in that, or there was no arrest, or he wasn't charged with anything, or there was no baby involved, or this child wasn't there. You need to really take a hard look at that. Because what happens down the line is once you file this notice, once you give them the notice, then 21 days later, if they have not fixed the problem, and you don't have to do it on the 21st day, frankly, you don't have to file it until after you, theoretically, after you prevail. But at least 20 days later, you have to wait, and you file the motion seeking fees under 57-105. And then when you win, the judge has to take a look at that and say, if there was no reality to those allegations, if those factual allegations had no reality, you prevail and your client gets fees. And if that legal position that was taken by the lawyer doesn't have a basis in the law, you get fees. And the fees presumptively are shared by the lawyer and the client who filed the bad stuff. Lawyer beware, it's presumptive. So the only way a lawyer gets out of paying their half is if they come in at the evidentiary hearing on the 57-105 fees, and now they're put in a position, a very unpleasant position, of having to say, it's my client's fault that I put that baloney in there. And then you've got to convince the court that you did your due diligence, because some of this case law that's in the outline that I emailed you guys, this is pretty tough case law. I love this quote from the Vaux versus Church case. About half the practice of a decent lawyer is telling clients they are damn fools and to stop. I mean, that's your job, as I see it, in part, is to tell people, I know you feel very strongly about that position. There is no legal basis for it. I'm not putting it in writing. I know you feel very strongly about that, but I have absolutely no evidence except you telling me that he hits the pipe all day long, and I don't mean tobacco. And I'm telling you right now, without some objective, how we're going to prove it in a courtroom, I'm not putting it in writing. I'm not putting my name on it. That's your job. Is a kind of a higher level to this. Judges, I don't remember a judge ever telling me this when I was in private practice, but I'm telling you right now, our memories are actually better than you think they are, and we're human. So when I have lawyers come before me that have a history of not bringing baloney, and they come in with a gut, visceral, unconscious, I couldn't do anything about it if I wanted to, credibility bump. They come in with a credibility bump over somebody who time after time, we read this stuff. I read every single pleading before a trial. I read every single old order. I read the entire thing. I read the pretrial memorandums. I prep my final judgments based on those. And this is what I find myself doing too often. Oh, back. They didn't prove that. Oh, back. That wasn't actually anywhere near in the realm of what was proved. Back. We know, and you all are developing your own little persona of credibility and reliability with each individual judge. And it doesn't take that much for there to be chinks in that. There are occasions where I think, God, I really thought that was a really good, bright lawyer. I can't believe what I'm reading. There's like no law in our land that would support what this is. I don't even know. I mean, did they do it because their client forced them to? Did they do it because they really didn't know? I mean, we don't know what goes on in your offices. So we have no idea whether you file baloney because you got buckled under by a client with a lot of money and a lot of passion and they convinced you to do it because you wanted the case that bad, or if you tried to talk them out of it and they talked you back into it, or whether you just flat out don't know the law. We don't know. But each time we get an experience like that, it's very, very difficult to put that out of your mind and treat you like fresh, pristine, don't know you from Adam lawyers the next time you come in with another client. So just keep that in mind. So lawyers are expected to do their own investigation. You're expected to do more than Sally tells me that he smokes dope all day every day. Okay, Sally, what makes you say that? What are we going to present in court? What isn't going to be hearsay? What's not going to be? You really have an obligation to do a lot more than I think is normally done. Uncorroborated claims do not constitute material facts. That is such a powerful concept. And let me point to something that happens in the courtroom as an example. All right, so your client Sally says he's at the crack pipe all day long. This happened, he left the child alone. The baby's diaper's always bad, blah, blah. So you go to trial. You have no eyewitnesses to this, of course, and you don't have anything but hearsay, which the judge isn't letting in. And so pipe smoker gets on the stand, and you know, isn't it true that you're a pipe smoker? No. Well, what about that time that you got arrested? That didn't happen. Well, what about that time this happened? That didn't happen. Well, what about time that didn't happen? That didn't happen. And then in closing, I've had lawyers argue to me the things that they asked the witness. Like, that's not, you being able to cross-examine somebody is not a corroborated fact. That's not evidence. Your questions are not evidence. So even if you say to pipe smoker, hey, what about that time you smoked crack 4 months ago? And he says, I don't remember that happening. That's not evidence that he smoked crack 4 months ago either. So you really, the reason that this needs to worry you is not even so much because there are that many people out there filing 57105 claims, because right now there aren't. I see very few of them. I think there should be more of them, and I think that lawyers have some sort of impression that judges don't like it, or that we see it as being, I don't know, not playing fair, not being nice. I can't speak for all of the judges. All I can do is tell you that it's a tool that is absolutely legitimate, and to me helps us cull out claims that I shouldn't have to be dealing with at the end of a year-long expensive litigation. And two, it offers judges a little bit of cover, because I think it's going to be a lot easier to get judges to award fees under the statutory basis than it is to not do this and hope that you can do it under the vexatious litigation bad faith case law, which we'll talk about next. Because that's the judge having to say you're a bad litigant, a bad lawyer, and they've got to be the bad guy. Whereas under 57105, you prevailed. Turns out that you didn't have any evidence of it. Turns out the law didn't support you, and that it's shall. And now the judge can say, I don't really have a choice. So I'd ask you to think about when it is that you can use that strategically and to pay more attention to that. Judge Barber, did you want to talk about anything related to that before I go on to vexatious litigation? No. Any questions on this end about 57105?
About on this end, any questions? No questions on this end?
Okay, we got one on this end. You say it, and then I'll repeat the question to make sure everybody can hear.
Would it be your suggestion that the 57105 motion then not be filed until you get a ruling or an order to determine whether you're the prevailing party or not?
So that's a great question. The question is, strategically, when do you file the motion? You've done the notice, you've waited the 20 days, they haven't done bubkiss. If you were in my courtroom, I'd say file it before the hearing, because it's just that little thing. Because the judges won't know about the notice you sent, but they will know that you filed the motion. And that is going to be, you know, just right up here going, no facts, no law to support it, I mean, we're going to kind of see where it's going. And you can actually ask for, notice that along with the trial and ask the court to make a decision at the end of the trial, depending on how they rule. So personally, I don't know that there's a big advantage to waiting. The other thing is, too, you've put you already have the bow over the bridge, and now you've said, okay, we've got the cannon pointing at you, because a couple of just little nuances to that. Your obligation as a lawyer doesn't just mean at the front end, I did my best, I did some investigation, these facts look right to me. When you go to the deposition, and I had a case in a dependency court where 57105 fees were a big, huge deal, because what happened is we went to the deposition and the department's case crumbled like a souffle. Well, there's a continuing obligation. So even if you're not going to get dinged for what you did, the fees prior to the depositions, if you go to depositions and all of a sudden somebody's case falls apart, they have an obligation then, a continuing one, to say, oops, I need to file an amended, there's a 57105 pending. So at any point along the way, if you realize that you don't have the facts or the law to support you, then it's your obligation to fix your pleadings. You can also, buyer beware, you can also get 57105 fees for filing an improper motion for 57105 fees. So I'm not telling you I don't want to, if I get people in this building calling me tomorrow and going, God damn it, Diana, everybody in the world's filing these damn motions. I'm gonna, hey. No, you got to be careful. I mean, you got to pick the ones where pick the ones where you know you're right. You got to know you're right. Yeah.
Just so I have the procedure correctly, once you do the safe harbor, you file your motion for your 57105, then the actual hearing on their bad motion, what you think is a bad motion, is heard first. And then you ask for your ruling on the 57105, like if you're the prevailing party at that motion?
So you can do it, I think you can do it a number of different ways. So you do the notice, which doesn't get filed, right. And then at least 21 days later, and I believe you could do your motion for fees under 57105 up to the trial on that issue, or you could even do it after you win. We were just talking about there potentially being some maybe advantages to doing it beforehand. And I guess I could think of situations where you want to wait until after, depending on the facts, but you could do it either way. The other advantage to doing it ahead of time is you could cross-notice that for the trial and ask the court to actually rule on those issues at the same time. I personally, whether it's 57105 fees or 6116 fees, I really like to get it all done at the same time. I hate this whole come back 6 months later with the affidavits, and I don't remember what the facts are. I barely remember what my ruling was, and I mean, I personally would prefer to do it all in one time. But I don't think you have to do that. You could wait, get your win, and then file the motion saying and the motion has to lay out. I gave them the notice on this date. I filed my motion on this date. There's time, at least 20 days in between, and I prevailed, and you got to give me fees.
I prevailed at their motion that got denied.
Right.
Okay.
Right. let's talk about the vexatious litigation for just a minute. So if you have a 57105 claim pending and you have what the judge might consider to be bad acts of the litigant or the lawyer also, and for example, you've got a are you okay? Are we? Yeah.
Okay, I apologize.
I had wanted to interject something, but
Yeah.
I tried, and apparently you didn't hear me, so I wanted to make sure we were communicating good. You can hear me now, though, right?
I totally can. What you want to say?
Okay. Well, it's a little bit late now, I apologize, but getting back to 57105 and the safe harbor motion, what about the instance where the safe harbor letter's sent to the attorney and the attorney files an amended pleading, but it really doesn't cure the defect? Now, do you think that the person is obligated to file another, or I should say send another safe harbor letter, or do you think that they can go ahead and file their motion for fees when the amended pleading does not cure the complained of defect?
So I know we've had a conversation about this, Judge Barber, and my feeling is because it's a continuing duty, you would not have to file another letter. But I think in practice, another letter would perhaps help if you had a judge that was either concerned about the notice due process part, or if there's, or if the changes that they're making, for example, it's one thing to have them take out things. I think if they don't take out enough, you're okay, you don't need another letter. But what if they change things up? I think you might need another one to put them on notice that these new allegations also are not based on fact, or your new legal premise is also not based in the law. So I think it might be a safer practice to go ahead and do another letter. But I don't know that you technically have to, assuming the same problems were in the new one as were in the old one, since it is a continuing duty. But I didn't see any cases directly on that issue, so another one I think would be safer. So when a judge has multiple ways that they can award fees,
Hang on,
Yeah,
Judge
go ahead.
Tennis?
Yeah.
I apologize.
No,
I don't
no.
want to get too far off, but we do have a question on this
Sure.
end, Ms. Silva.
Yeah, it's my understanding, I heard you initially say that it no longer has to be, frivolous. It just needs to not be well-based in the law or fact. Does that mean that the standard of proof is no longer a scintilla of evidence, that there's a justiciable issue?
Did you hear the question?
I did, and I believe that that is accurate. I'm looking for the case. It's cited in the materials that talks about the fact that you no longer have to prove frivolity, and it is Section 4F. Right. So it's I don't believe that it has, the scintilla thing is there. I think it's got to be well-based. So there has to be a firm, a legal basis, and the facts have a basis. So to me, that means that if you make claims that you have no proof of, and you know you don't have any proof of at that moment, that you're susceptible to having fees lodged against you. And if at some point you lose the evidence you thought you were going to have to support that claim, I think you're also in dire straits, potentially. But I'm glad you went back to that, because the one thing that I did want to point out that is perhaps should be the most frightening, although I believe, have you ever sua sponte awarded 57105 fees, Judge Barber?
I have not.
Okay, because I haven't worn off on you quite enough yet, but that doesn't mean it won't happen. I have, and the danger of having a judge do it is you don't get your 20 days. You don't get your safe harbor. You just get, you said this, you brought me no evidence, Where is it that you thought you were going to get your evidence? I had a witness that didn't show up in a subpoena that I talked to personally that I thought was going to give me this. Okay, all right. But you better have somebody or some basis to believe that you're going to be able to come into this courtroom with admissible evidence of what you claimed, because I'm tired of spending my days litigating stuff that everybody knew full well from the beginning. What she just thought or hoped or suspected that he was at the crack pipe all day. You better have some basis for thinking you're going to prove that, because there's some pretty serious allegations. I don't want to see allegations of sexual abuse unless you've got a basis in fact. Not just your client saying, I think this happened. You better have some admissible evidence coming in. So that's the danger of judges using that statute, is you don't get a way out. You're kind of stuck. So vexatious litigation. I think the thing that makes this so difficult for judges, and I don't know, I'm just going to take a little poll in this room. How many of you think it's hard to get judges to award fees for bad acts on the other side? I always did. And it's my impression that there's a couple reasons for it. One is that judges are generally nice people and they don't like to piss people off, which I personally think is a lame reason not to do it, but I think that is a reason. The other reason is it all gets so murky. It gets so murky because it's so rare that there's only one bad actor. It's usually like super bad actor and got fed up and now has done some of their own, and now it's a back and forth and everybody's got dirt on them, and it takes a lot of time and memory, and it makes it very difficult. So that's part of the other problem. The other problem is, and I know you have to have this happen to a million times, you'll come in, they didn't do discovery, and you'll say, I want fees. You won't have an affidavit. You won't be kind of all queued up, and you'll say, Judge, could you just reserve? And so the judge reserves. And how often do you actually ever get those fees? Nobody ever goes back. I probably have 4 million reserved attorney's fees orders that I've signed because people weren't ready to do it right then. If you have a motion, at least in front of me, if you have a motion related to discovery dispute, or there's an order, they didn't follow it, something along those lines, and you have to come to a hearing, somebody's paying somebody's fees. You didn't give the discovery, you're paying fees. That's the only way. In my mind, that's the only way. That's the only tool lawyers have to go back to their clients and go, no. I need the bank account records. No. I need the financial evidence. I mean, that's the tool you have, is to say, you know what? I know. I'm telling you right now, 100%. She's going to make you pay their fees. I'm telling you that right now. That's the only tool you have. And I feel like that's the only tool I have. But when you come into those hearings, at least in front of me, bring an affidavit of time, and Judge Barber's going to tell you more about that. Be ready to actually request the fees that you want. I want to give fees as sanctions for people who are not doing what they want to, but you've got to give us the tools that we need to do that. And if you don't have them, then say, Judge, can we set a hearing now for the fees issue? And I'll get out my calendar and we'll set a hearing now. Or call up later and actually set those things for hearing, because they just kind of get lost in the ephemera, and it just kind of, then nobody ends up, there's no deterrence to that. When you're going read over the case law a little bit when it comes to bad act and bad faith litigation. The rules and the findings are much more strict than, for example, 57105 fees. So it really is, you really got to give your judge a lot to get fees based on those kind of bad act things that aren't based on the statute. The last thing I'm going to talk about before I turn it over to Judge Barber is an area that I feel is in a little bit of flux. And that is the fees that, the amount of consideration a judge can give at the end of a trial to who was reasonable in their desires, requests, expectations, negotiations, and how to balance that with the need and ability to pay. And there's a couple of cases out of a couple different districts that are kind of in opposition about that. We have the new case, the Palmer case, out of the First. And basically, in the First, they believe that need and ability to pay really, really, really needs to be that guiding force, no matter who came in and asked for the sun, the moon, the stars, and lost. There's a case called Halleck out of the Fourth, which seems to indicate that you can take into account a little bit more people's negotiations and who rejects what offers. So in my feeling is that no matter where the judge comes down on balancing those two things, you cannot ignore need and ability to pay, because that can never be ignored. But as far as the relevance of people's offer of settlement, I think it's totally relevant, admissible. I want to know about it, only as it relates to the fees. Yes, Ms. Lomas.
How are we getting negotiations in? I've always heard, I don't want to hear negotiations.
It's relevant as to the fees issue, Judge. I have an offer of settlement that I said. Now, and it may be your judge you could do it one of two ways. If the judge is already bifurcating the fees issue, then you got no problem, because you're bringing it in at the fees hearing, and you say, Judge, you ordered $400 a month in alimony, and we have an offer here where we offered her $2,000 a month in alimony, and here we went to 4 mediations on this topic, and that's this much of their bill is based on the obvious this was never going to happen. Or they kept asking for you to make him do X, Y, Z. Here's where we kept telling them there's no law. You know, that's kind of a little backdoor 57105. But at any rate, those things are admissible when it comes to fees. You can argue unreasonable positions, even if it doesn't rise to the level of a 57105. You can still; those are still relevant factors that a court can use to award fees if the parties' situations are equal financially, or you can use it to reduce fees for somebody who, under normal circumstances, might have a right to most or all of their fees getting paid. So just want to point out to you, there's a lot of case law that says there's a lot of things that we can consider other than need and ability to pay, although, again, that is still, I guess I would call it a super factor, very important. So, Judge Barber, unless we have some questions related to those issues, any questions on that end?
Yes, we have one. Mr. LaBona? Try to speak loud, or if she can't hear, I'll repeat it.
Let's just talk about is that true for motions for consent as well, or just for updating a whole trial?
Are offers of settlement negotiations true for contempt proceedings as well?
What was the question?
If an offer of settlement would be admissible for fees related to a contempt proceeding?
That was the question, yes.
So, I don't know, I don't think that there's any particular type of proceeding that this theoretically would not be available for, although I'm having a hard time just in my head picturing a factual scenario where you've got somebody who's in contempt of a court order. I mean, you're really not going to need, I guess if they were in contempt of a I'm having a hard time. I'm having a hard time just picturing the factual scenario, but theoretically, I think this would be admissible anytime there's somebody asking for fees.
Okay. All right, and I would agree. I don't know if this is a situation where you're just dealing with maybe alimony. That's the only thing I can think of right off the top of my head. If there was an offer for the payment of less than arrears of alimony, I don't know. But something along those lines. It's hard. Enforcement's usually dealing with child support and or alimony or something of that nature. But I agree with Judge Tennis. Procedurally, I don't see why not. I mean, you can do it for trial. You could do it for the hearing. I don't know of any bar to it. Just don't know offhand of the applicability right away.
All right, we got one more question here, and then I'm going to, you go ahead.
Is there a case that talks about negotiations being relevant for fees?
Yeah.
There's materials, that's fine.
Yes. There's under 3, chapter 61 fees, it has respective positions. There's a whole deal in there. All right, Judge Barber, why don't you talk about our more typical 6116 fee situation?
Okay, as y'all know, the statutory basis for Chapter 61 fees is in Florida Statute 6116, which says a lot of things, but in main part it says that a judge from time to time, after considering the relative financial positions of the parties, can award fees. And the reason for the statutory basis is to place parties on equal footing as possible so that they can both secure competent counsel. Do know that whether or not, though, that your request for fees is based in statute or in contract, you still must plead it. It has to be pled in the petition or the motion, or it's waived. There's a case in your materials, the Watson case, that stands just for that proposition. In that case, the husband filed a petition, the wife answered, fees were never pled. They went to trial, and the court went through a lot of findings as to alimony and need and ability, incomes of the parties, set child support, did an unequal distribution, and then found entitlement to fees, even though it wasn't pled, it wasn't argued at trial. And after the judgment was entered, the attorney for the wife filed a motion for fees, I suppose maybe under Florida Rule of Procedure 1.525. That's the rule of procedure that says you can file a motion for fees within 30 days after rendition of judgment or the notice of voluntary dismissal being entered. But if you look at the family law rules of civil procedure, it clearly says that 1.525 has no applicability in the family law rules. So that case is illustrative of that point, that it's got to be pled or it is waived. That case also points to a Supreme Court case called Stockman v. Downs. And in that Supreme Court case, it's a civil case, but they pointed to it in Watson. And that case kind of carves out an exception when fees are not pled, and says if somebody was placed on notice, because remember, it's all about notice. That's why we have to plead fees. But if someone was otherwise placed on some kind of notice and they, by their conduct, acquiesced or they didn't object, then fees can be properly before the court. So in preparing, what came to my mind is, what about a situation where fees are never pled, but somebody sticks it in their pretrial memorandum, okay? And say the wife is seeking attorney's fees, or maybe they'd even go as far as to say the wife is seeking attorney's fees in the amount of X. Is that something that is properly pled? And I think the answer to that is it just depends. It depends on the conduct of the attorneys. Are they discussing it? Has there been an affidavit of time that has flowed back and forth? Has there been any objection to it? There's another case that the Stockman case points to that, again, it's a civil case, but in that case, fees were never pled, and they did include it, though, in a pretrial statement. And subsequent to trial, under 1.525, the attorney filed a motion for attorney's fees, and the court said that it was good enough for it being in the pretrial memorandum because the other side was placed on notice. So I think it really is fact-specific, and it does depend, but do recognize that there may be situations where if it's placed in a pretrial memorandum and not otherwise objected to, there could be conduct that would lead a court to rule that it was you were sufficiently placed on notice.
Judge Barber, could I jump in there for a second?
Yeah.
So I think along the lines of what you're talking about is you can waive your right to have all sorts of things pled. And so I think if the danger is that if you get a pretrial memorandum and you don't go back and compare that to the original pleading, and you go forward and you're all arguing about whatever this issue is, for example, this, attorney's fees at the trial, it's very easy to trial these things by consent and you figuring out later or arguing in your closing statement, oh wait, gotcha, that wasn't in your pleading. I think that's where it's not so much that a pretrial memorandum is a pleading. I think that it gets wrapped up in this trial by consent. But I do see a lot of times where we're talking about things at trial. It's hard for me because I like to be involved in probably more than I should. So Dad will not have pled for the tax deduction, and here we're having this big old discussion at the trial about the tax deduction. And all Mom has to do is say he didn't plead for it and he doesn't get it. But at the end of it, now I got to figure out, was it tried by consent? Was it not tried by consent because nobody said out loud, we're doing this by consent? Was it in the pretrial memorandum, because that makes it look a little bit more like consent? So I think there definitely needs to be a little bit more going back and looking at the original pleading on your way to trial. I got one question for you on this end, Judge Barber. Go ahead.
So if it pops up for the first time in the pretrial memorandum, what do you do? Move to strike it?
I'd either move to strike it or do that as a preliminary issue at the trial.
We didn't hear the question on this end.
The question was, if you see in the pretrial memorandum, I want to talk about the tax deduction or I want attorney's fees and it wasn't pled, I would probably, if I were the lawyer, I'd probably wait until the trial starts and said like a couple preliminary matters. I'd like us to make sure we take these off the table because they weren't pled and we're starting the trial right now. That's, I think, the safest way to do it.
Was the argument back being safe there's a link between that trial and the trial date?
Well, that's why I'm saying that the cases, my feeling is a pretrial memorandum is not a pleading. It only becomes trial by waiver and notice sufficient when you go through the whole thing and you're litigating it. And now, if they're sending you discovery related to that issue, then I wouldn't just give them the discovery on it. I would, but I don't think that a pretrial memorandum in and of itself is sufficient as long as you make clear at the front end of the trial, I'm not trying this by consent. I don't agree to have that issue dealt with.
And while we're talking about trial by consent, that is Rule 1.190 subsection B, I believe, of the Rules of Civil Procedure. And that's the whole rule about pleadings relating back and amendments to the pleadings and conforming the pleadings to meet the evidence. So that rule specifically tells you that things that are not pled can be tried by express or implied consent. So again, like Judge Tennis just indicated, if somebody starts to mention something at the trial and it's not properly pled, object. Don't let it go any further. Object and shut that door. Okay. Anything further there?
No, ma'am.
All right. As far as fees for contempt and enforcement, Florida Statute 6116 also indicates that from time to time the court can impose fees not only for initial proceedings but obviously for modification and enforcement proceedings. There is a case in your materials called, I believe it's Power. Hang on one second. Yeah, Power. And that case just underscores that we still have to consider first need and ability as the poll star, but it also talks about the consideration in contempt and enforcement actions of the Rosen factors. And y'all are, I'm sure, familiar with the Rosen factors, the length, the scope, the duration of the litigation, whether it's brought on to frustrate or stall defenses or claims, that kind of thing. So do know that even in situations where somebody is being held in indirect criminal contempt and it's emanating from a 61 proceeding, the first thing that we must consider, though, or the primary factor is need and ability, but we can also look to the Rosen factors. All right. I next want to talk to you about once fees are properly pled, entitlement to fees, what's next? What's needed at the hearing? Well, you need to have an evidentiary hearing. There has to be testimony. There has to be testimony of the attorney that's seeking the fees. There has to be some evidence as to the reasonable hourly rate, as to the number of hours required. We have to have that evidence of the parties' relative financial positions in order to determine need and ability. Need and ability findings are generally required except for in temporary relief situations for interim fees. The courts are allowed broad discretion in awarding temporary fees, and there's a case in your materials of Caluso that seems to indicate that even if a court doesn't make the proper findings in a temporary fee award, so long as the record has sufficient evidence of need and ability, then that's going to be good enough. Also, there is a case, two cases in your materials, Deravere and Baker, and those cases deal with the proposition that temporary fees are not a vested right. The court can go back in a temporary fee award and adjust it in whole or in part. There is a case also that's not in your materials, and I wanted to discuss it because it brings on a little bit of a different layer other than just the Rosen factors and need and ability. It is the case of Woodward versus Berkeley. It's recorded at 714 Southern 2nd, 1027. It's a 4th DCA case, 1998. And that case was a paternity case, and it actually involved Tom Jones. I don't know if any of y'all are old enough to remember Tom Jones. I'm kind of embarrassed to say I am. But apparently he had a concert, and he had a one-night stand with a woman, and it resulted in the conception of a child. And she sued him in the state of New York for paternity, and he gave her a very generous settlement. He gave her $33,000 a month in child support, tuition to college and private school, and some other things. It was a very generous settlement, but it was non-modifiable. The child support was non-modifiable. And New York law sanctioned that. It apparently was okay under certain circumstances in New York to make child support non-modifiable. Well, she was not happy with that. Years later, she lived in Florida. She moved to domesticate the foreign judgment and seek to modify the child support. She had Tom Jones served. He wasn't a resident of Florida, but she had him served when he came here to do a concert. And she moved for interim fees. He had voluntarily given her about $20,000 in temporary fees. She wanted more. And the trial court, without going to any other legal principles of the case, whether or not Florida really had jurisdiction, whether or not the New York law should apply to the contract they made, just gave her like $138,000 and more in temporary attorney's fees. And the reason that I like this case is that Rosen was decided right before this case. So it deals with the court needing to look to the Rosen factors in the award of temporary fees. And it deals with 6116 because paternity actions, 6116 applies to paternity actions in terms of fees. But what it also instructs the court is it's the court's duty and responsibility in determining an award of interim fees to actually think about those legal principles, to think about, wait a minute, even though he didn't raise in personam jurisdiction, does the court have jurisdiction over him? Even though Florida doesn't allow for non-modifiable child support, New York does. So is this action even sustainable here? So that case tells us that it's incumbent upon the court to actually look at those things, and that case reversed that temporary fee award, which is rarely done. Reversed that temporary fee award, sent it back down to the trial court and said, look to the merits of this litigation first before you decide whether or not you're going to award temporary fees and how much. Okay. Do you also know that a court can order a party to fund litigation through their own assets if they find that the party is being vexatious? And that's the Schmitz case located in your materials. The Martin case is one of the few cases that actually deals with what is income disparity. And that case says that a party who made 2.5 times more than the other party that was a sufficient income disparity when consideration of the relative financial positions of the parties for the awarding of fees. The Balco case tells you that the court cannot look solely to incomes. We must, again, that's what the statute says, the respective relative financial positions of the parties, that's what we look to. The Tresser case is, I think, a very important case. I used this as a practitioner successfully a couple occasions because other practitioners just weren't aware of it. But in assessing attorney's fees, that case says that you must first, when determining incomes, take away from the paying party whatever they're paying every month out in child support or alimony. And not only that, you have to subtract from the receiving spouse's income their child support contribution pursuant to the guidelines. So do be aware that when the court comes into incomes, just don't say, oh, he's making 95 and she's making 35 before you do that adjustment. Okay? Now, what proof is needed at the evidentiary hearing? Well, you need your billing statements or a summary, and you need to redact out whatever information may be confidential. We actually need evidence of need and ability. So my preference is if you're going to rely on financial affidavits, I will take judicial notice if the parties agree to that, but my preference is that you actually introduce into evidence the documentation, whether it be the financial affidavit or anything else you're relying on. Certainly evidence of the Rosen factors, if that's going to be argued, testimony from the attorney. And we know that pursuant to 6116, you do not need expert witnesses to testify. It would be good to have an affidavit as to the reasonableness by an attorney that's viewed the file and looked at it. There are some objections also that you can make. A lot of people, for whatever reason, when I have fee hearings, don't object to the entries on the other party's billing for whatever reason. I don't know if it's because they don't want to upset the other party. I don't know if it hits too close to home or what, but oftentimes when I'm looking through time records that are attached to the affidavit of time, I see things that if I was still a practitioner, I'd certainly be attacking. I do know that clerical time, that is not something that should be taxed against the other party. 57104 is the computation of attorney's fees statute, and it tells you that time can be billed for legal assistants who do non-clerical services that perform a valid support of the case. And preparing a notice of hearing, preparing a letter is not it. That's clerical services. So you should be attacking those things. Unit billing. You cannot bill flat rates. You have to bill actual time spent. So that's something that you can attack. Hand holding. If it's obvious from the face of the billing statements that you're having way too many telephone calls or conferences or what have you, if it looks like it's hand holding, that might be something you either want to further investigate prior to the hearing or at the time of the hearing. Travel time for an attorney that is out of town is not allowable. While you're entitled to competent counsel, you're not necessarily entitled to seek the time of an out-of-town attorney who has to travel a great distance. And duplicative efforts of successor attorneys or multiple attorneys. That is something that you can also look to because that is objectionable. Also know that if you want to object to a cost, especially somebody such as an accountant or, I don't know, any other expert that's hired, you need to place that objection well in advance of the evidentiary hearing on fees. And the reason is because the other party should be on notice that you're objecting to that cost, and if they need to get a witness in to testify as to the reasonableness of that cost, they should be able to do that, and they wouldn't be able to do that if they didn't know you were objecting ahead of time.
Judge Barber, can I interject a couple thoughts?
Yeah.
So I have a lot of compassion for what it takes to get a case ready for trial, and I get how it's always so much more than you thought it would be, and I totally get that. But I see so many attorney's fees presentations at the end of these horrible, long, agonizing hearings and trials that really did not get the time that they deserved, and it really is having an effect on not just the amount of money that we're able to give you, but the vulnerability of those orders on appeal. So a couple of things that come to mind. Number one, I know it's difficult to get the attorney's fees affidavit out in a timely fashion, but when I have one lawyer that says, hey, here's I've been working for 3 years on it, and I just sent it to him yesterday, and him stands up and says, I was a little busy last night, that to me is just that's not fair. And now it means that we got to kick the can and do something else. And so if you can get those bills out timely, and then when you get them from when you don't have the impecunious spouse, when you got the money-making spouse, and you get that thing in, take some time with it. Just as Judge Barber was saying, so often I have lawyers want to argue to me that the fees were unreasonable when they didn't ask the first question. I mean, you're the one who's been preparing the case. I don't know whether that was reasonable or not. If they're asking for $100,000 and your guy only spent 30, point that out. If they're, I mean, take a little bit of time and spot check. Did the mediation really take 5 hours, or did you bill 2 hours? Or is there enough specificity? If somebody's challenging it, email, phone call that's not a sufficient record if somebody's challenging it. We are theoretically supposed to do our own independent look at these time records and determine what is reasonable. But the reality is, if the other party, the other lawyer, doesn't care enough to cross-examine this lawyer a little bit, to push a little bit, to say, what about on this date, why would that have taken so long? Or what about on this date, I spent this long on it, and how could you have spent that much on it? Or, hey, you said you drafted this motion. The reality is I drafted that motion. If you don't take some time to, you can do it in a nice way. It doesn't make you unprofessional. That just means you're giving the court some information to base a decision on. Because if you don't do that, I feel like this lawyer saying this is the time they spent. Who am I? I don't know what time he spent. So definitely give it a little bit more effort than you have. But again, if you're the one with the money-making spouse that is really at risk of paying those fees, and you get in those time records sufficiently reasonably ahead of the hearing, send them a letter that says, hey, I've got questions about these. Send them something. Highlight their copy and send it back to them and say, this is what I'm going to question you about at the hearing. Otherwise, we have the opposite side of that situation happening, and you're saying, well, what about on this day? Who'd you send the email to? Well, they don't know, and now, again, we have to kick the can down the road. There was something else that I wanted to... Something that I'm always curious about, but very rarely does anybody tell me, is what the other guy spent. I find that, to me, that if you're the client who's the doctor making $1 million, and she's the stay-at-home mom who's getting back into real estate making 15, and she's asking for 70, and he paid 200, if you're the one asking for the 70, ask the other guy how much he spent. I think it's proper, frankly, and that guy won't know because he's not going to know what he spent. I think it's proper if you say, Judge, I'm asking for fees based on need and ability to pay. I think it's relevant and important for you to know what everybody spent so that you can look at what reasonable is. I would like to put that lawyer under oath and ask him how much he spent, or I would like to enter the records that I requested from him, showing how much they spent. To me, there's some information that I would like that I don't always get. We've got a couple questions here. Go ahead.
So if you have time entries from the other side that has work detail that would be work that you should be receive fees for, but then also within that detail is like a lot of clerical work and things like that, and it hasn't been carved out, the burden of proof would then, I think, be on the person trying to get those fees, but curious as to how the judge sort of looks at that, or how you look at that from the standpoint of rough justice. I mean, how do you do it?
That is a great question. So what happens when you get in the blobbo time, 2 hours spent doing this and this and this and this and this and this and this, which technically you're not supposed to do, and you're defending against the fees? Do you tell them ahead of time, hey, listen, you need to chop that time up to the degree, or I'm going to be questioning you about this, or I don't think that's the way it should be done? Or do you wait till the trial and say, Judge, they didn't prove it because it's block timing? Off the top of my head, my response would be, I would be tempted, if you got the bills in sufficient time ahead to know there was a problem, and you didn't let them know there was a problem, my gut sense is that I would probably say, you're right, that's not how it should look, but I'm not going to be super technical about it, and now we're going to have to, you need to do a new affidavit, and we're going to come back, and if you can, convince me that you figured out how it got chopped up and that's reasonable, I'm going to go forward. I don't like the concept of gotchas or technicalities when it comes to stuff like this, but I don't know. Judge Barber, do you have a different feeling about
it? I hate to keep saying stuff like this, but I just kind of harken back to my own practice. And I knew those cases where I was going to have to be asking for fees and those which I wasn't. And I would keep detailed single entry time records on those cases where I was going to be asking for fees. And then you redact that information as far as what might be confidential before. So I am kind of the persuasion, and everything's case-by-case analysis, but I'm kind of this persuasion that it should be a single entry and it should be detailed. If you are the proponent asking for the fees, you need to put on a decent case.
So you're going.
I don't know.
You're going to be bad cop in that situation.
I'm not going to help them out. Yeah.
Yeah. So the tough thing about that is, you're never going to know which way the judge is going to go on that. That's going to be the problem, because I could be tough on a lot of things, and you're going to have no idea going in that I'm not going to be like, hey, you didn't do it right, never mind. It's going to be really hard to know.
But you know when you take a case or when you're into a case, you know which cases that you are not going to be litigating fees and which cases you are.
You shouldn't be doing block billing.
You just know that within your office.
Yep.
So,
Ms. Lois?
And
yep.
Can you talk briefly about if you're going to go into trial and you try to negotiate about getting fees prior to trial, for trial, like estimates of what is the time it's going to take? If you've got the housewife mom and he's making the money,
You're talking about temporary fees?
I guess it would be temporary fees, but estimated for trial time. Can you ever get those, like going into trial?
So this is, Judge Barber, this is the question, and I got to admit, I feel a little bit of confusion about this, although I do it all the time. The question is, when you're going in on your temporary fees, can you say, and I think it's going to take me another X hours to do this, and do this, and this deposition, and then for the final trial?
Yeah.
I think you can, because it's temporary, and it's fixable afterwards. Now, that doesn't mean, though, that you can go to the trial and say, well, I spent what I got, I'm good with that. No, because the other side can tell you, I want your time entries to make sure that you actually spent what you said you spent. You can't get a windfall. But I think because it's a temporary award, you can do the estimation, and I grant those, so I think...
And I think a motion for temporary fees, I think it would be a good practice point in a motion for temporary fees to really lay it out. If you expect that there's going to be 10 hours to get yourself to trial, then there's going to be 10 additional hours to get myself to trial. If you think you're going to need a court reporter for a 4-hour trial, then the per diem for the court reporter is X. and this is the company that I am thinking about hiring, and this is what they charge, and I'm going to call an expert, and the expert charges X per hour, and I anticipate the expert to be on the stand for an hour to hour and a half or what have you. But if you lay that all out instead of just putting some big number in your motion or just not putting any motion at all, the other side is on notice, and it really does help the court in fashioning a reasonable interim fee. Again, interim fees, there's broad discretion. The case law is very clear that courts are rarely overturned on appeal. But if you lay it out in your motion, you're putting the other side on notice, and you're also preparing yourself, really, for, okay, how much more am I going to need in attorney's fees and costs to bring this matter to trial?
That's a great point, because the other thing it does, it has everybody, all, the litigants and the lawyers, all thinking about the thing that you always underestimate. You always underestimate how much time and money it's going to take. So you always end up with a client who cannot believe the final tally of this thing. But when you go through it and go, it's going to take this and this and this, and you show them, then at least you're not going to be, they're not going to have sticker shock at the end. And if you've got the client who is the bread maker, perhaps that's the time to have the conversation about, you know, you can throw this much at her now, or you can throw this much at the two lawyers over the course of an agonizing 2 years. That's really doing them a favor, or at least you've given them the option. And if they decide they want to go take it to court anyway, at least later you can say, hey, it's not like we didn't all know that this was going to be a very expensive, probably on you situation. So I think those are good conversations to have.
And don't be too concerned either about, okay, if I put all that out in my motion and I expend that money and more, and I'm going to need another request for interim fees, I'm hamstrung by this. No. I mean, the statute does say from time to time, so you can come back for another award of interim fees. You might want to make it clear in your motion that this is your best guesstimate or estimate based on the information available to you at that point in time. But I can see where someone would say, I don't want to get too detailed in that motion because I don't want to be hamstrung to that if that doesn't carry me through to trial and I have to file another interim motion. So I wouldn't be too concerned with that.
Any last minute questions?
We have one from Ms. Silva.
Okay, I got one on this end, and then we'll do Ms. Silva's.
Gotcha, okay.
So my question is, okay, so not temporary, but you're at the trial and you realize, okay, we're actually going to try this sucker, right? So you put your fee affidavits together and you do all that. When you do the estimated time for trial, how do you, as the judges, see that, right? Because of course we do always underestimate. And is it okay just to say, all right, I think, because you sort of have, it's sort of a game of timing, right? You got to get to the other side, but you also probably haven't prepared so in advance because you're hoping you're going to settle it. At least this is how I do my life.
Right.
So what's the best practice?
I guess I would say I would probably plug in the amount of time that you've been given for the trial. If you already have like a trial date, you're going to know you have a whole day. Put in the whole day, or you've got 2 days. Or not that you're getting 2 days out of me, but you know, put in that whole day, or that 3 hours, and then. But I think that you can absolutely testify that in addition to that, Judge, as you can see, it's now 7 o'clock. We ran over by 2 hours. I'd like another $500 or whatever that is. So I think your best intelligent guess is always going to be fine as long as you follow it up. If there's a court reporter with a record of, and I'd like to add an additional because we've run over or whatever. I think that's the only way you can do it, honestly. And Ms. Silva's question?
Yes, Judge. Two procedurally concerns I have. One, we never have enough time at the end of the trial to start arguing and objecting about reasonableness of somebody else's fees. So I wonder if there's I know you want to do it all at once, but you know, it's 5 or 5 and we haven't quite gotten to reasonableness of the other person's fees. Is there a better way for us to maybe time that? Number one. And the other thing is I'm very uncomfortable putting another attorney under oath in the middle of a trial on other issues.
Why?
I fear that as I question them about reasonableness, this, you did this, why did you do this, that I'm somehow gonna breach the privilege, or I'm gonna run up against that with the client's present. So I'm just not sure how to handle that.
I didn't totally understand what you meant about not feeling uncomfortable questioning the lawyer about the time spent. I'm not totally clear on what you mean, what the concern is.
What I mean is, you had mentioned, you put the attorney under oath. So we're in a divorce trial, a custody trial, whatever, and before closing, we're on attorney's fees, and now, if I'm understanding you correctly, you want me to call counsel here and put him on the stand under oath about his time records. And I've just never, I don't know, I'm a little uncomfortable about how to do that without disrespecting the privilege between him and his client and what he did.
Well,
does that not make sense? I'm sorry.
No, I get it. I mean, I think there's a lot of people who don't feel comfortable cross-examining their fellow lawyer because you have an empathy that you wouldn't like to be questioned about your time record. So, I mean, it's not that I don't understand that, but I think it's just being professional about it and asking reasonable questions. I don't know. Now, I guess a lot of times this does tend to happen at the end of the trial, and you're right, if you run out of time, you run out of time, we got to kick the can, but I don't know. From the bench anyway, I don't see it as particularly a big deal for one professional to say, hey, what about this, what about that time, this entry doesn't have anything. I just think that that's the price you pay for having to request fees is having to justify those records. I don't know. Ms. Lomas?
I don't think there's anything wrong with just asking a court to find entitlement and set the fee hearing for another day, too. You can always do that if you feel like you're going to run out of time.
Yeah.
Well, they have to be there, but I don't think you need to necessarily list them as a witness. No, because I think it kind of goes without saying. That's the attorney that you're going to, I mean, in an abundance of caution, okay, maybe. But I don't think that it's mandatory. I mean, it's not like I'm going to grant their motion to exclude themselves as a witness because you didn't list them as a witness. So, yeah.
Yeah. Well, no, I mean, you certainly can always request, anytime attorney's fees by either side is an issue, I think you can legitimately request protection from the other side to get those redacted time records so that you can, because it's going to be a lot harder for somebody to say you spending this time is not reasonable when their time records have the very same time. It's going to be very, very difficult for them. But it's the times where things are super out of whack and somebody is spending 3 and 4 and 5 times more. Then at some point you got to say there's something going on here, and it's probably not fair to the guy who's not spending as much. But all right, did everybody get the number on that end? Anybody still need the number?
We need it again on this end. We had some folks come in a little bit late, so if you could state it again, please.
It's 160-601-7, N as in Nancy. Thank you all very much. I don't know if we're going to fit another one of these in this fall before the holidays, but we will try. We appreciate it. If you want feedback or want to give us feedback, please do so. Give us an email. Have a great day and weekend. Thanks. Thank you, Judge Barber.
All right, thank you all. Thank you.